On behalf of Brinks, Hofer, Gilson, and Leon, hello and welcome to the virtual panel presentation entitled Patent Reform, What Should You Be Doing Now, Part 3. I am pleased to be joined by today's presenters, Andrew Stover and Dominic Zanfordino. Drew Stover, a shareholder at the firm, is the chair of the Patent Prosecution Practice Group. He was named leading patent practitioner recommended in Illinois by IAM Patent 1000, the world's leading patent practitioners, in 2012. Dominic Zanfordino, a shareholder at the firm, is a member of firm practice groups that include the Intellectual Asset Management and Litigation groups. He was named Illinois Super Lawyer for Intellectual Property Litigation in 2007 and in 2009 through the present. We believe today's discussion will provide you with practical guidance on the upcoming changes stemming from the passage of the America Invents Act. Today's virtual panel offers 1 hour of CLE credit in Illinois. We are happy to apply for CLE in other states at your request. Please note the window below the video that states CLE tracking. There will be random check-in points during the discussion where you will be asked to enter basic information into the window provided to prove your attendance. After today's program, your CLE certificate of attendance will be sent within 10 business days. We welcome your questions. Submit questions throughout the program via the chat window on the right-hand side of the screen. Our panelist biographies and today's presentation can be found in the top left of your screen. Click there to download that at any time during the program. And now today's presentation, Patent Reform. What should you be doing now? Part 3.
Thank you. Good afternoon and welcome to Part 3 of Patent Reform. This is the third installment of a three-part series. Our firm introduced Patent Reform presentation last spring where we highlighted some of the things that people should be thinking about, both in-house and outside counsel. Then last August we had a second installment where we looked at some of the changes that were coming into effect in September of 2012, including the oath and declaration. And then today we're going to talk about a few different things with a focus on the changes that are going to be coming into effect on March 16th of this year. Now, with all of the information that's been out there in various blogs, literature, hopefully discussions have been had with your counsel, a lot of these things shouldn't be a surprise. But a lot of these provisions are very dense, is the word I'll use, and thick, require you to sit down and read them again and again. And hopefully today we'll get through some of the highlighted provisions, give you some ideas on strategies that you could take going forward, both in planning for March 16th and for things after that. So the overview of the presentation is going to look at the AIA changes that are taking effect on March 16th. The most important of those is going to be the first inventor to file system. And we're going to talk about that, both what that means, what is the basis for it, what is the effective date, etc. Also, a very significant change taking place is the way prior art is going to be defined. It's going to be a much more narrow collection after March 16th, and that's going to affect the decisions that you're making in terms of when you want to file applications. Derivation is also going to be coming into force on March 16th. So some of the things we're going to be looking at are what laws you want to apply. Do you want to be under or before the March 16th date, or do you want to be filing an application, for example, after that date? Also, what steps should you be taking before March 16th, both to get applications filed, but also to prepare for after that date and the changes that are coming into effect. Dominic, he's going to be addressing a few other things that aren't necessarily dependent on that date.
Right, I'll try and talk a little bit about derivation proceedings that come into effect on March 16th, and I'll also give sort of a recap on inter partes review and post-grant review. Both of those proceedings came into effect last September, and give you a status update on what's been going on since then.
So let's talk about the first inventor to file system. Again, it's going to be taking effect March 16th, 2013. The America Invents Act moves the U.S. from a first to invent system to the first inventor to file system. As all of us who have been practicing for a long time know, the first to invent system provides you with an opportunity to show an earlier date of conception a reduction of practice and diligence if required, in order to annotate a reference. The move is going to be towards this first inventor to file system. Now, the primary purpose, at least as it's been advocated, is to harmonize the U.S. with other jurisdictions, other countries. And so we should all be familiar with those. For example, Europe having a first to file system, and how we've had to deal with those different jurisdictions in the past. So some of those changes are going to be instituted in the U.S., and we need to be comfortable with how they're going to be implemented. There are some differences, and we'll be looking at those. So, first thing, understanding the first inventor to file system. The first true inventor is no longer entitled to the patent after March 16th. Again, under our current system, if you could show a prior date of an invention and conception, corroborated, however you wanted to support that, that would be the key date for determining patentability. That's no longer going to be true. Now it's the first inventor to file, or, and there is an exception, publicly disclose the invention. And you'll be entitled to that patent if, and the key here is that looking at the effective filing date or that date of that public disclosure. That's going to be the key date for determining patentability. And we're going to talk a little bit about public disclosure and whether that should be used as a sword or as a shield, and some of the cautionary notes that should be taken under consideration when considering that. Now, although there is this first inventor to file system, there are some exceptions. The first exception is public disclosure by the inventor. If within 1 year of the effective filing date, will not bar the patentability if the disclosure was made by the inventor or one who obtained the disclosed subject matter directly or indirectly from the inventor. So if the inventor or one who obtained the information were happen to disclose the information, it's not going to be a bar if within 1 year you file your patent application. Another exception is if there's a disclosure by a third party. That will not bar patentability if the disclosed subject matter was made public by the inventor, again, within 1 year of your effective filing date and prior to that third party's public disclosure. Now, at the same time, that public disclosure can become prior to the third party. So in this scenario, it's used both as a sword and a shield. It's a sword to their any filings they might want to make, but as a shield to the filing that you want to make. Another exception is common ownership. Now this is where the subject matter disclosed in the claimed invention not later than the effective filing date of the claimed invention. So that's a key thing to take into consideration. We're looking at the effective filing date. If not later than that, the subject matter disclosed in the claimed invention were owned by the same person or subject to an obligation of assignment to the same person, then there won't be a bar. And we're going to talk a little bit later on one tool that you can use to ensure that you at least have this obligation of assignment to hopefully avoid, or rather take advantage of, this exception. So which system applies, the new or the old? And again, the key here is the effective filing date, and that's going to determine whether the application is treated under the new AIA law or the law as it exists right now. Now the effective filing date, again, repeating these terms is very important. For claimed invention is the actual filing date. So for example, if you file a brand new application after March 16th, it doesn't have any right of priority or benefit of an earlier filing date, that's your effective filing date. Some applications, though, are going to cross over the line. And if you have an invention that's entitled to a right of priority or benefit of an earlier filing date, it can have an effective filing date prior to March 16th of this year, so that you can continue to take that chain of cases out and maintain the protection of the laws as they exist right now. Now, one thing that you should note here is that the new system, the new first inventor to file system, applies to any application that contains or contained at any time claims to an invention with an effective filing date after March 16th. So in this situation, if you have an application and you're trying to claim back in front of that March 16th date, you have to be careful when you file the application that you don't have any claims that are in essence new matter, new subject matter, or have only that effective filing date after March 16th. Because what happens is the entire application then is going to be treated as having that effective filing date. And there can be intervening prior art and other problems created by that. So, first thing to do, which law do you want to be under? Do you want to be under the current law, or do you want to be under the new law? And at first blush, it seems like in most circumstances you're going to want to file before March 16th. But there are a few exceptions to that. So, under the current law, you can still take advantage of the swearing behind. And under the new law, you won't be able to do that any longer. You won't be able to annotate references by showing this prior invention. So that's one advantage of filing now. Another advantage is the definition of public use and sale, or what prior art is going to be changing. Right now, public uses and sales are those that are made in the U.S. After March 16th, they're going to be looking at sale and use anywhere in the world. So the collection of prior art is going to be greatly expanded. The other change is going to be published U.S. patent applications with foreign priority claims. Right now, the prior art as of their effective U.S. filing date. After March 16th, you're going to go back to the foreign priority date. So again, it's going to be expanding the collection of prior art that could be applied against your application. So those would be good reasons to file now under the current law. Other reasons, and Dominic will touch on this, but one thing is filing before March 16th avoids the being subject to post-grant review. If you're concerned about that procedure or how it might be applied to your applications, then make sure you file before March 16th. The other thing is there's going to be some uncertainty about how the new laws will be interpreted by the courts. There's the phrase, otherwise available to the public. What does that mean? And it's going to take some jurisprudence to define that. Are the courts going to look to publicly conducted experimental use exception as it's currently applied? And so, if you want to avoid that uncertainty, again, get in under the wire before March 16th. Finally, you're going to avoid uncertainty regarding the forthcoming new USPTO rules, which should be coming out shortly. Now, you might be sitting there asking, why would you want to be under the new law? Well, one situation that you want to consider is whether you have any secret commercial use, or for that matter, secret sales, that right now would be barred from getting protection, i.e. they've been going on for more than a year, you missed a certain date at some point in time where you could have tried to have patented that secret use, etc. But it's too late now. Under the metallicizing engineering case, that will be considered a prior art activity. Under the new law, that is not necessarily true. And so something that you've been using secretly for some time may be patentable after March 16th. Again, there might be some uncertainty around that, but that seems to be what the legislative history supports in terms of this interpretation. And the other thing similarly could apply to secret sales. So, bottom line, again, I think if you look at all these considerations, the vast majority of the time you're going to want to be filing before March 16th to take advantage of the provisions that are in place right now. So, what are some steps to take for filing? First of all, we have some considerations for in-house counsel or others that might be in charge of your client's portfolio and are the liaisons either to other inside patent counsel or to outside patent counsel. Things to do before March 16th. And some of these, hopefully, is a repetition of what was being told to you last August and even last spring when we did our first two presentations. One, you need to be reviewing and making filing decisions on all existing invention disclosures. You should be cleaning out the attic, harvesting those things that are key invention disclosures, and then prioritizing them. Are there some that have a real long development cycle time? For example, some inventions might take a year or 2 years to develop. And have those been sitting around or ready for patenting? You should make sure you get those in, because those are the kinds of things you might want to rely on your first conception date and be able to annotate references. Do you have very strategically important inventions or inventions in highly competitive technologies? again, you can prioritize, make sure you're getting those filed before March 16th, and then move on from there. The other thing is you want to be encouraging inventors to document all their inventions that they might have laying around in their drawers or desks or shelves, and let's make sure that you have the complete environment of inventions so that you can do this prioritization step. Next, but not least, obviously, you need to be communicating with your patent counsel, whether, for this matter, it's outside or inside, and recognize that the counsel that's actually preparing these applications is going to be dealing with a lot of last-minute requests from many different clients, and that is already happening. People's plates are getting full very quickly. So to the extent you can get in the queue early, we recommend that you do that and make sure that we meet any filing deadlines. Another consideration before March 16th are third-party publications. Now, often clients will have a monitoring system in place. Perhaps you're monitoring other competitors or prolific inventors or certain subject matter areas or even some kind of word queue, and you receive search results based on that for recent publications or issued patents. You should be looking at those and to see if there's any that are kind of close or things that could become a bar to any applications you want to file. Again, some of these things that maybe you have in your file drawer laying around, things that if you would be able to swear behind if you were aware of them. So again, look at third-party publications or issued patents for that matter. Sometimes they could have been subject to a request not to publish, and see if there's something that you have where you want to have a date of invention conception preceding that publication date. Something you're going to want to be able to swear behind, whereas if you file after March 16th, you're going to be out of luck. Steps to take for filing by March 16th, I have outside counsel, but this could also apply to prosecuting attorneys that are in-house. Timing issues. Recognize it'll be a last-minute rush. Plan accordingly. To the extent you can be getting things done right now and out to the client, approved and filed, the sooner the better. Even though March 15th is going to be the grand filing day, kind of like tax day, it might be a good idea if you have something ready not to wait till the last minute. Be a few days early. There's going to be potential 102 references. If everybody's filing on the same day and somebody got in a little earlier, then you're still going to have to think about swearing behind some of those references. So again, even there, you're going to want to preserve all your conception and diligence evidence to make sure that you can get behind those references. Another consideration is if some of this inventive activity has taken place in a foreign country, which might have their own foreign filing license requirements. So applications need to be filed by foreign associates in advance of that date, so then you can bring them back into the U.S. Again, it's just something in terms of timing that you should be thinking about. Let's talk briefly about drafting strategies. First thing, you want to make sure that these pre-March 16th applications meet the enablement and written description requirement. There's also the best mode. That's not going to be litigated, but it's still a requirement at the Patent Office, but especially enablement and written description requirements. If you have to cure a case, an application after March 16th by adding something, you're out of luck. Now you're going to be under the first inventor to file system. Intervening applications can become prior art. So make sure that your applications are complete with respect to enablement, written description. As part of this, you should be looking at maybe some applications that were filed quick and dirty, provisional applications. Maybe they were filed because there was a potential bar you were worried about, a trade show or something of that nature. Make sure you look at those and that they meet the enablement and written description requirements. If you need it, file another one right now. It could be another provisional or it could be a non-provisional, but add whatever material you need to, and then within 1 year of the first case, go back and claim priority to both. But make sure that you have a full application on file before that date. Advising foreign clients. Now, a lot of foreign clients are already subject to these kinds of rules. But if you have a client that is sending a lot of applications to you, and then you're having to do a lot of work to bring them up to speed to make sure that they meet these different requirements, then let them know now that there's this date. And I think probably should have already done that, hopefully. But make sure they understand that you're going to need some lead time to make sure these applications are ready to go before the March 16th date. More drafting strategies. Disclose and claim everything you can. If filing provisional, file with claims. If filing last minute, make the application as complete as possible. You know, sometimes people think about provisionals being the skinny applications. Personally, I've never recommended that. I think you should always include claims. Make sure you have your vocabulary defined. Provisionals do provide the advantage of not counting against your 20-year terms. There can be some advantages there if a lot of the value of your invention is going to be at the tail end. But if you're looking at filings provisionals, you're up against the gun, the last minute, you know, make sure you do something else. Is there boilerplate you can throw in there from other applications of similar subject matter? Is there some disclosure from previously filed applications? Incorporate by reference if needed to previously published or issued patents to make sure that you have a lot of that information that might be required for the written description and enablement requirements. So planning for March 16th, plan now, get prepared. Now this is applicable to not only the things that you need to be doing in terms of filing applications before that date, but after March 16th, the world doesn't end, and we're going to have to go on and be ready for the system that's in place at that time. So you should be taking steps to get ready for that as well, in terms of filing things that are going to come under the umbrella of first inventor to file. Get streamlined, be agile. So one thing you need to think about is developing, and if you don't have this in place, and hopefully you do, a tracking and recording system of pre-filing public disclosures by the inventor or anyone in contact with the inventor. Remember, we talked about an exception that if there is a public disclosure, even after March 16th, that you can rely on that, but you need to file within the 1 year. You have your effective filing date within 1 year of that time. So you need to include the date, details of disclosure, is there any corroborating evidence, et cetera, things that you would ordinarily want in any event to support, dates of conception and the like. This might be especially important for technology not covered by filed applications. Of course, if you have all of this information and it's documented, there's going to be duty of disclosure issues if you ultimately file the application. You should be making the patent office aware of it. Establish a cohesive patent strategy. Again, knowing the big picture for your business, and then how do the details relate to that big picture? Which invention disclosures are the key ones in terms of prioritizing? Maybe you want to file early in an invention development cycle. Maybe you want to have a rolling filing process if you do have a long cycle time period, so that you're not waiting the last minute and a lot of intervening prior art has come along. And then again, prioritize and don't let bureaucracy control. If you have a committee that sits and they meet on a certain date and have to have all the forms signed and dotted, those things can slow the process down. The next slide applies directly to that. Let's shorten the invention to filing process. Once the first inventor to file system is in place, we want to shorten that process. So right out of the gate, first thing, very helpful as a practitioner, is when I get a very complete invention disclosure. It has hopefully some drawings or other pictures or information. It's got a written description, at least an abstract, telling me what the invention is, how it works, what are the materials, any important things. And we need to educate our inventors on doing this. To the extent, we get a very thin disclosure, a couple of sketches, it requires time and effort to then go back and harvest the additional information that you need to prepare an adequate application. Set timetables for this disclosure review. If necessary, have the inventors ready to go and present at those reviews so that they can explain or promote the invention and decisions can be made more quickly. Set timetables for conducting reporting searches and drafting applications, and that can apply to both in-house and outside counsel who are handling those types of activities. And when you have those timetables set, monitor the metrics. How is everybody doing? Are we getting our invention disclosures prepared? Are we getting them out? Are we getting our searches back in a timely manner? and are we getting our applications filed? And after monitoring that, evaluate it, determine if changes need to be made. Again, I'm not going to advocate not using provisional applications. I think there's a lot of benefit, the term being one of them. But don't file skinny provisional applications. If you file something and you have to add a bunch of stuff later, then that's going to start a new clock ticking. So get as much in there as you can. Again, full and complete invention disclosures are going to allow for good provisional cases. One thing to consider is an obligation to assign with these invention disclosures. I mentioned that was one of the exceptions. If you have an obligation to assign, that can then avoid a bar due to something that was filed earlier where you do have that common ownership. Include detailed claims and drawings. And then again, use these rolling provisionals. File them at different time periods of the developmental cycle. And then, after 1 year from the first case, you could roll them all into a non-provisional U.S. case and move forward, and your international cases as applicable. Now, when we're crossing over that line, so we have some pre-AIA cases, and now we're crossing over the line. It's after March 16th. What do we do then? We want to make sure that we're not coming under the new law, because then there's going to be a whole new collection of prior art that could be applied. So, we have to be careful about what we're putting in those new cases. If we have claims that aren't supported by that original case, then that could kick it into the first inventor to file world. And if there's just one claim that makes that application susceptible to first inventor to file, then the whole case comes under that umbrella. So you want to be very careful there. One strategy is if you are coming close to the line, maybe file two cases. One that clearly is entitled to the priority and is going to track things that were in the first case, and then a second case maybe where you're going a little far afield. Another, obviously practitioners, when we're looking at cases, want to be at least be allowed to be our own lexicographers. And we want to be able to rely on the specification and drawings, et cetera, to develop new claim strategies. And that might be due to what we see in the competitive environment, et cetera. So when we are filing new claims, we still will be able to argue that they're supported by the new case. So another strategy is to just file an identical copy of the prior application, maybe amending the first sentence to claim the priority or putting that in ADS. And then filing a preliminary amendment a day or two later that introduces a new claim. So now, the first application that you filed, or the day you file it, that's my application. It's clearly the same as the prior case and entitled to that prior effective filing date. And here's some new claims I'm going to introduce. And by the way, they're supported by that case. Publication, the Patent Office is kind of discretionary, but a lot of times those preliminary amendments will be picked up for publication if that's important. If not, you can always request publication. Okay, strategic public disclosures, and put big cautionary note around this, and you'll see on the next slide that you should really be proceeding with caution. And this is where you want to use a public disclosure perhaps as a sword. And as the law on its face provides, public disclosures can be used to preserve patent rights prior to filing an application, and it can be used to bar competitor patent applications. And this is as a result of this grace period exception to the public disclosure. But proceed with caution. And here's a few things to consider if you're thinking about making these types of public disclosures. First, you're likely going to bar any kind of foreign protection. That's something you should already have in your mindset when you're making a public disclosure is, hey, I'm going to be forfeiting foreign rights. And that's just something that automatically comes to mind. And usually go through that decision process and filing, or the public disclosure outweighs any kind of foreign rights you might be interested in. But now it's also going to be applicable here, and just keep that in mind. The other thing is to show that you had this prior public disclosure, to rely on it, either as a sword or as a shield. You're going to likely need a lot of support, documentary support. You're going to need declarations. You're going to need to show when it was made, who it was made to, how it was made, and what was made. And that's the last thing. There's going to be some uncertainty as to whether the subject matter is the same. There's, looking at the legislative history and some other people that have been talking about this, it almost has to be identical. So if a third party comes along and makes some mere insubstantial changes or only trivial or obvious variations, then that might void your reliance on this. So I think my advice here is still to file an application prior to any kind of public disclosure, instead of trying to use it as that sword. Now, of course, if you inadvertently make a public disclosure, you should document it, get all the information in line, docket it, make sure that you're aware of it so that you can deal with it as the need comes. Either, so when you do file something, you're within the 1 year for your effective filing date, or that you can get around any intervening third-party prior art. And that's all I'm going to say. I'm going to turn it over to Dominic for the next section.
Thanks, Drew. It's good advice, especially the advice to get in before the last-minute rush. I'm reminded of the stories about the long lines at the patent office back on June 7th of 1995 when everyone was trying to get under the GATT treaty. So, all right, I'm going to talk about derivation proceedings first, and then I'll wind up with a brief discussion about inter partes review and post-grant review. Now, derivation proceedings is one of the new aspects of the AIA that will go into effect on March 16th of 2013. And by way of background, I'll remind everyone that 35 U.S.C. Section 102F of the patent statute provides that a person shall be entitled to a patent unless, under Section F, he did not himself invent the subject matter sought to be patented. Now, this is the concept of derivation. Derivation addresses originality. The question is, who invented the subject matter that's the subject of a claimed invention? Now, the new Act provides for a proceeding that is designed to ensure that the person acquiring the patent is the true inventor and did not derive the invention from someone else. Derivation proceedings, like other proceedings, need to be initiated by a petition, and that petition needs to be filed with the Patent Office within the 1-year period following the date on which the patent containing the claim was granted, or the earlier application containing the claim was published, whichever is earlier. Derivation proceedings are going to be conducted before the new Patent Trial and Appeal Board in a similar manner to inter partes review and post-grant review. Now, one of the important things to keep in mind is that the petitioner who is going to be challenging the patent that's the subject of the derivation proceedings needs to have its own patent application on file before initiating the derivation proceedings. And in this particular case, the petitioner will be allowed to copy the earlier filed application, assuming it has support. By that I mean the petitioner has support for the copying. Now, the petition itself has to set forth with particularity the basis for finding that the person filing the earlier application derived the invention from the petitioner. Now, the standard is going to be whether the invention is the same or substantially the same as between the challenged patent claim and the patent claim being proposed by the petitioner. Now, the board can decide to defer a decision on whether or not to institute derivation proceedings until 3 months after a patent that is the subject of the petition issues, or it can defer or stay while there are any post-grant proceedings in place. And that's because the whole question of derivation can become moot if, for example, the patent office decides that the subject matter that is covered by the challenge claim isn't even patentable in the first place because of prior art. Now, that decision by the patent office of the patent board is going to be final and non-appealable. So it's very important that your petition provide all the evidence that you think is material to the grant of the petition. There really is no point in holding back at this point. The petition has to demonstrate that the petitioner has standing, which usually means that the petitioner has a patent application on file. It has to identify the relief that's being requested, which is usually a finding by the board that there was a derivation of the claimed invention. And there has to be the submission of substantial evidence in the form of an affidavit that addresses at least 2 points: a communication that went from the purported inventor of the claim that is the subject of the petition and the petitioner's inventor. And there also has to be a showing that there was no authorization to file the challenged patent application. Now, the showing of communication is going to have to be corroborated. It's not going to be enough for the petitioner to submit evidence that there was some form of communication between the two purported inventors here. It's going to require documentary corroboration, much in the same way that today we have to show corroboration of conception and reduction to practice. Now, what does this all mean? Well, I think contrary to popular belief, the AIA is still going to require well-kept and detailed records of conception and reduction to practice, because you're going to need these things in the event of a derivation proceeding or a question of derivation. But on top of that, you're also going to have to maintain evidence surrounding the circumstances of the disclosure between the two so-called inventors here. And that might include correspondence logs and whatever evidence that can be amassed at the time of the communications. This is going to be very important, I think, in situations where there are joint development activities going on, because for those of you that are familiar with such activities, often in those cases there is a question of who invented what and who should be entitled to file a patent application. And sometimes there's a race to the patent office as between purported inventors. And so another thing that I think is going to be important here with respect to derivation proceedings is an obligation on the part of parties, especially those that are in joint development proceedings, to keep monitoring or keep a close eye on what's happening in the patent office to find out whether your joint developer is himself or herself trying to patent the inventions that are coming out of the joint development efforts. Now, just a couple of other points to touch on. Parties that are involved in derivation proceedings can settle those matters. Those agreements have to be consistent, however, with the evidence of record, and any settlement terms can be kept confidential. They don't become a part of the file history. So not only did the AIA create these derivation proceedings for the PTAB, but they also amended the patent statute. Now, 35 U.S.C. Section 291 now provides, well, will provide as of March 16, 2013, that one patent owner can bring a civil action against another patent owner whose patent, the second one, claims the same invention and has an earlier effective filing date. Now, the basis for such a civil action will be that the invention claimed is derived from the inventor of the invention claimed in the patent owned by the person seeking relief in the civil action. Now, before I go on to the next slide, it's important to keep note of that first bullet point. One patent owner can bring a civil action against another patent owner. And the reason I raise that is because if you look at Section 291B of the new statute, there's a filing limitation. And the limitation reads as follows: an action under Section 291 may be filed only before the end of the one-year period, beginning on the date of the issuance of the first patent containing a claim to the allegedly derived invention and naming an individual alleged to have derived such invention as the inventor or joint inventor. So what does that mean? Well, the defendant in such a civil action has to be a patent owner, all right? And the statute talks about bringing this action within a year of that challenged patent issuing. But if you remember from my previous slide, the plaintiff in such an action has to also be a patent owner. So this limitation in my mind raises the question of whether these two patents actually have to issue within a year of one another, and I'm not sure what's going to happen if they don't. So going on now to inter-parties review. Inter-parties review actually has been in place since last September of 2012, September 16th of 2012. And the topic of inter-parties review has been the subject of our prior V panels. And so I'm just going to touch on the highlights of inter-parties review before talking some more about what's been happening since last September. So as many of you may already know, inter partes review, sometimes referred to as IPR, replaces the old inter partes re-examination proceedings. Now the IPRs are going to be conducted before this new PTAB, which is going to consist of a 3-judge board instead of just one examiner. And the petitioner is going to need to be a person who is not the patent owner, and that person can request cancellation of a claim of any patent. Now the grounds that can be raised for cancellation have to be based on either Section 102 or Section 103 of the patent statute, and which essentially consists of patents and printed publications. Now, in order for a petition to be considered, you have to meet the following requirements. You have to submit the required fee, and that's been recently reduced, and I'll talk about that in a second. The petition has to identify all the real parties in interest. It must identify with particularity each claim being challenged, the grounds upon which each claim is being challenged, and the supporting evidence, which would include copies of prior art and any printed publications, as well as affidavits and declarations of supporting evidence. Now that petition is going to be public. Now the standard for instituting an inter partes review is this: the board will need to find that there is a reasonable likelihood of success with respect to at least one challenged claim in the petition. And there are a series of documents that the patent owner and petitioner can file in sequence, but the point of it is all that by statute, the board has to reach a decision on patentability within 1 year of deciding to institute the inter partes review, which typically will happen within 6 months of the petitioner seeking review. Now, in an inter partes review, the burden of proof is different with respect to validity, is different than it is in a district court. Before the PTAB, the burden of proof is preponderance of the evidence. In a district court action or other civil action where patent validity is being challenged, the standard of proof is clear and convincing. Now, to the extent there are any confidential or other secret information that needs to be disclosed or discovered during the proceedings, the parties can operate under protective order. The federal rules of evidence are generally going to apply, and as I just pointed out, they've got to get to a decision within a year, although for good cause that time can be extended for up to 6 months. And again, parties can settle these matters. The agreement has to be in writing and filed with the Patent Office, and to the extent there's going to be confidential terms to the agreement, it can be submitted under seal. The important thing is, remembered, if the parties reach settlement, there is no estoppel effect. Now, some things to keep in mind with respect to institution of an inter partes review. Review will be barred to the extent the petitioner has filed a civil action challenging the validity of the patent that is the subject of the review, which typically would be a declaratory judgment action of invalidity. Now, that bar doesn't apply to a situation where a petitioner is sued for patent infringement and decides to file a counterclaim challenging the validity of the patents. And by statute, there are some automatic stay provisions. To the extent there's civil litigation pending, the institution of the inter partes review will stay that. Now, upon a final written decision regarding any claim that is the subject of an inter partes review, the petitioner will be barred from requesting a proceeding in the Patent Office, another proceeding on those claims, and the petitioner will be stopped in any civil action or any ITC proceeding or other types of civil action as to challenging challenging validity of those claims. Now, what's been happening since the inter partes review proceedings were instituted back on September 16th? Well, originally the Patent Office estimated for fiscal year 2013, which comes to an end at the end of September of this year, the Patent Office estimated that there would be 460 requests filed. Now, if you look at the data, at least through January 7th of this year, there have been 99 requests. So you can see that's probably a pace of just under 300 requests for the year. We looked for January, for example, there's about 3 to 5 requests being made a week. And so they're clearly behind the pace that the Patent Office estimated. Now, looking at the petitions that have been filed, you can see that the technological areas where these petitions are being, or patents are being addressed, break down, as I've indicated here on the slide. 59% of the petitions come in the electrical field, 22% in the chemical field, 7% in the mechanical field, 11% in the biotech field, and then 1% with respect to design patents. As of January 7, 2013, who are the most common petitioners? Again, as I portrayed here on the slide, Oracle, at least through January 7th, had filed 11 petitions, Corning filed 10, and then you can see some other corporations that are listed that have filed 7 or less. Now, who are the most common patent owners that are having their patents challenged under inter partes review proceedings since at least through January 7th? Clouding IP, LLC, has had 11 petitions filed against its various patents. And then you can see DSM IP Assets, 10, and down the list through Xilinx, 4 petitions filed. Now, in terms of fee structure, one of the, I think, issues that has come up since the proceedings have been instituted back in September of last year is the high cost associated with filing for inter partes review. Under the original rules, the fee for filing a petition was $27,200, and that allowed you to challenge up to 20 claims. And to the extent you were going to exceed that 20, it was $250 for each additional claim. That amount was due at the filing of the petition. And to the extent the board decided not to issue or institute inter partes review, there was no refund. So there were some regulations recently published that will go into effect. The rules will go into effect as of March 19th of this year, where the fees will be staged. So in the case of an inter partes review, there will be a $9,000 filing fee and a $14,000 institution fee. And you can see those add up to $23,000, which is about a 15% difference between what the original rules provided for. The $9,000 filing fee will allow you to challenge up to 20 claims, and then there's a $200 additional fee for any excess claims. The institution fee allows you to essentially try 15 of the claims, and there's a $400 fee for any additional claims in excess of 15. And my understanding of the way this is going to work is you're actually going to have to pay that entire fee up front, but then you would get a refund of the institution fee to the extent that the board decides not to move forward with an inter partes review. So another thing that's of recent note with respect to inter partes review is some technical amendments to the rules that took place a few weeks back to eliminate a so-called dead zone. Inter partes review, as I said, has been available since September of last year, but according to the way the rules worked, you couldn't challenge a patent under you couldn't petition for inter partes review to challenge the validity of one or more claims in a patent until 9 months after the patent issued. And so that created this waiting time, if you will, where once the statute was enacted back in September, became effective back in September, there were some patents that were essentially too new to be addressed by these proceedings. And the technical amendments that were passed a few weeks ago got rid of that dead zone. So to the extent any of you out there have been considering inter partes review and have been waiting for that 9-month period to pass, that's now gone. You can file immediately. The only thing you may want to consider is the fact that if you wait until March 19th, the fees will diminish potentially significantly. So another issue that's come up recently is the provision of the inter partes review rules that create the so-called one-year statutory bar. So if you look at Section 315B of the patent statute, 35 U.S.C. Section 315B, the rule provides that an inter partes review can't be instituted if the petition is filed more than a year after the petitioner or real party in interest or a privy of the petitioner is served with a complaint alleging infringement of that same patent. So to keep inter partes review as an option for accused infringers that are sued in a district court action, the inter partes review petition needs to be on file within 1 year of service of the complaint. Now, there was a recent ruling by the board concerning one of the earlier filed inter partes review proceedings. I think it's number 4. It's styled Makauto, I think that's how that's pronounced, USA versus BOS GmbH. In that case, the facts were essentially these. BOS had filed a district court infringement action against a petitioner, a future petitioner's Taiwanese parent, who I'll refer to as Makauto Taiwan. Makauto Taiwan wound up signing a waiver of service form that was provided to it by the plaintiff in the district court action, which was BOS. And so, to the extent those of you out there aren't familiar with that proceeding, typically in a district court action, the plaintiff is required to serve the defendant, personally serve the defendant with the complaint and a summons to appear in court. But the rules do provide an option whereby a plaintiff can go ahead and send a letter and some forms that the defendant can execute, waive formal service, and there are some benefits associated with that. It allows the defendant more time to answer the complaint. That's what the parties in this case, in the district court proceeding, used, but one of the things that BOS didn't do, which the rules require if you want to later prove a service date, was you need to file those waiver forms with the district court. Later on in the case, there was a voluntary dismissal taken by BOS, and it was taken without prejudice because of some dispute that arose with respect to personal jurisdiction. So after that all happened in the district court, Makauto USA filed a petition for inter partes review of the same patent that was the subject of that earlier litigation. And in response, BOS argued to the PTAB that the inter partes review proceedings should have been barred under Section 315B. And what BOS argued was that the complaint that had been served on Makauto Taiwan, which was Makauto USA's parent, had been served more than a year before the petition for inter partes review had been filed. The board rejected those arguments and recently decided that the inter partes review proceedings could continue and that they weren't barred, and they did so on 2 grounds. First of all, looking at some long-standing Federal Circuit precedent, the board found that the voluntary dismissal that BOS took in the district court litigation essentially nullified any follow-up service that took place in the lawsuit. Secondly, the board said that the BOS hadn't even established a service date under the statute due to its failure to not file the waiver of service proceedings in the district court as the federal rules require. There was a separate issue in the case as to whether Makauto Taiwan was the real party in interest or privy of the petitioner, Makauto USA, and the board decided it didn't need to reach that issue. So what are some of the lessons to be learned from this early ruling by the board? Well, for accused infringers who perhaps hope to someday be future inter partes review petitioners for the asserted patent, they need to be very careful to calendar the statutory bar date, because they will need to bring their petition within a year of that date. Now, for patent owners who may find themselves as future inter partes review respondents, a couple of things they need to keep in mind, at least these, which are the patent owners have to be able to prove up a service date to be able to preserve their statutory bar defense. And the patent owners also have to recognize that any actions that it takes, similar to the voluntary dismissal that was taken in the Makauto District Court proceedings, potentially erases the statutory bar. So the last subject I want to talk about here is post-grant review. And again, this has been the subject of our earlier V panels and has been discussed extensively. So I will touch upon the high points. Again, like inter partes review, post-grant review became effective on September 16, 2012. But the practical reality is that it isn't in effect right now because it's limited to those patents that Drew spoke about extensively that are filed on or after March 16th of 2013. So one of the things to keep in mind for anybody considering post-grant review is that the petition has to be filed within 9 months of patent issuance. And similar to the rules with respect to inter partes review, the petitioner can't be a patent owner and can't have previously challenged the validity of the patent in a civil action. So these proceedings are going to be conducted by the PTAB. They share a lot of the procedural and aspects to inter partes review. The petition for post-grant review will essentially seek to cancel one or more claims of an issued patent. And like inter partes review, the petitioner needs to identify all real parties in interest and has to identify with particularity the grounds that form the basis for the challenge. And those grounds are broader than the grounds available under inter partes review. For example, a challenge under post-grant review can be based on a Section 101 statutory subject matter, can be based on Section 102 or 103 prior art defenses similar to what can be raised under inter partes review, and also Section 112, enablement and written description requirements. Now, the threshold for instituting post-grant review is different than the standard for instituting a inter partes review. It's actually a higher standard. The standard for instituting post-grant review is a finding by the board that it's more likely than not that at least one claim of the challenged patent is unpatentable. Again, a lot of the procedures are similar to inter partes review. The documents are going to be publicly available. The burden of proof is going to be preponderance of evidence, which is different than the clear and convincing standard for invalidity that exists in the district court actions. There is going to be some limited discoverability available, and there are some procedures that the patent owner can take to amend claims during the proceeding. But it's important to remember the claims cannot be broadened. So again, like inter partes review, there's been a recent change in the fee structure for post-grant review. Originally, a petition required a fee of $35,800, which would allow you to challenge up to 20 claims with an additional $800 fee for claims in excess of 20. That was all due upon the filing of the petition, and to the extent post-grant review wasn't instituted by the board, there was no refund. So under the new fee structure that will go into effect on March 19th, the filing fee is now $12,000, and the institution fee is $18,000, and depending on the number of claims that are the subject of the review, that amount could go up. And I think it's going to work the same way as I suspect it's going to work with inter partes review, which is the entire fee will be due up front, but to the extent that the proceedings aren't instituted by the board, then the petitioner will be entitled to a refund. So the reality is, given the fact that post-grant review only applies to patents that have an effective filing date on or after March 16th of 2013, and they only apply to issued patents, we're not going to be seeing post-grant review for some considerable amount of time. Now, I guess it's conceivable that some fast-track patents issue sometime in late 2013 or early 2014, in which case review proceedings might be instituted. But really the takeaway all of this is if you don't want your patent to be subjected to the post-grant review proceedings that are going to be coming into effect, then you need to have those patents on file before March 16th of 2013. So just briefly, I'll touch upon some of the issues that come up when one needs to consider whether or not to bring a post-grant review proceeding or a inter partes review proceeding by way of petition in the Patent Office, or whether to wait and allow those challenges to be made in the district court proceeding later on, depending on circumstances. And so one of the things to keep in mind is you know, before the board, you're going to be talking strictly about the validity issues, and in the while in a district court proceeding, you know, you're taking it all into account, and often it's the case where parties will be arguing, well, if the patent's infringed, then it's invalid. And, you know, there's claim construction issues where parties have to walk the tightrope, if you will, more finely between infringement and invalidity. Again, the burden of proof in a district court proceeding to challenge a patent is clear and convincing, and before the patent office, the question will be preponderance of the evidence. So I talked about the 1-year limitation for these proceedings earlier, and also the estoppel effect has to be taken into account. I know that seems to be one of the big disincentives right now to folks considering whether or not to bring an inter-parties review. It's not quite clear to folks what the extent of the estoppel will be, and so that's something you'll want to carefully talk about with counsel before making the decision whether or not to proceed. So with that, that concludes my presentation, and now we have some time for questions. I understand folks may have been submitting them along the way as we were speaking here, so we're going to check our files and see what we have.
Here, it looks like we have a couple of questions. First one, does a secret sale invalidate a first inventor to file application if made more than 1 year before the effective filing date? I'll take this one. I kind of touched on that in the earlier presentation, but the way the new statute is written, it talks about on sale or public use or otherwise publicly available. The legislative history appears to, at least in how the way people are interpreting it, that sale also needs to have been a public sale. So, and that seems to be, you know, again, in harmony with what the law is in other jurisdictions, where a secret sale, as long as it's not otherwise publicly available, would not be a bar to a later filed application having an effective filing date, more than a year.
Yeah, I mean, I agree. I think that makes sense, but it'll be interesting here to see how, you know, courts take, you know, current existing law and then trying to take into account how these decisions are implemented in other jurisdictions and try and meld those two together and see if that's going to make sense under the new law.
That's right. For example, experimental use will be interesting to see how the courts address that.
Right. So another question that we have relates to the estoppel effect on from inter-parties review. So the question is, does the estoppel relate to the entire patent that's the subject of the review, or just the claims that are being challenged? So my understanding is that the estoppel only relates to the claims that are being challenged. So for example, if in an inter-parties review proceeding, the patent that is the subject of the review has 4 claims, and the petitioner is challenging, say, claims 1, 2, and 4, doesn't challenge claim 3, then there is no estoppel with respect to claim 3. The petitioner won't be barred from challenging the validity of claim 3 in a subsequent district court action, and the petitioner also can file a later petition challenging claim 3. But again, there'll be all the fees and costs associated with that separate proceeding.
Got it.
So.
It looks like we're out of time. We would encourage anybody that has any other questions, please, you can email me or Dominic, and we'll get back to you as soon as we're able with an answer.
Thank you.
This concludes our presentation. Don't forget to download our panelist biographies and the presentation before you tune out. And note that your CLE certificate of attendance will be sent within 10 business days. Thanks to everyone for joining us.